Good morning, Mr. Seleka. Good morning, everybody.
Morning, Chairperson.
Good morning, Chair.
I understood that Mr. Berry was delayed on the way.
Pardon, Mr. Chairman?
I understood that you were delayed on the way or something.
Yeah, I forgot that I had to
Okay.
fetch my wife from hospital and I had to make arrangements for that.
No, that's fine. That's fine.
Thank you, sir.
Okay, all right. Good morning, Mr. Koko.
Good morning, Chair.
Thank you that you are back.
I thank you too.
Mr. Seleka, we adjourned at around 10 2 days ago.
Yes.
I'm hoping that 2 hours or so would be enough. How much time do you think you need?
Are you asking the right person, Chair?
If the leader of evidence doesn't know what's going to happen. Or did you take the attitude that now we are given Wednesday, so
No.
we can go wide?
No, not at all. Not
Yeah.
at all, Chair, because my estimation last time was that I could personally finish within an hour's time when we went into the Tegeta matters.
Yeah.
When we started the Tegeta matters.
Yeah. No, I just want to have an idea, so.
Yeah,
So,
let's budget, well, let's estimate 2 hours for it. I hope it takes less than that.
yeah, no, that's fine.
Yes.
That's fine. If it takes less, all the better.
Yeah, indeed.
Okay, all right.
Yes.
Mr. Koko?
Chair, there's an audit trail on Tegeta, which Mr. Seleka is not touching at all, which is important for you when you make the judgment. Audit trail that is backed up by documentation
Yeah,
that we can't ignore.
yeah,
And I'm going to try to refer to it. I felt under pressure last time,
Yes.
the day before,
yes,
and I
No,
did not sleep properly.
No, that's fine.
That I did not go through
Yeah.
the.
No, it's important that.
These documents are dated, they are sequenced, they are
Yeah.
proper.
Yeah,
And unless you look at that audit trail,
Yeah.
it's difficult to come in at the end and say, tell me about the 1.6 billion repayment, or tell me about the cooperation agreement. For example, I want to deal with the cooperation agreement and show you how irregular and unlawful it is.
yeah, no.
And Mr. Seleka starts post that. So
No,
I
that's
really
fine.
need to go through this audit trail.
No, that's fine. It's important that with the allegations that have been made against people like you,
Against me in particular.
the process is such that you don't have a lot of complaints when we are done, that you have had a fair opportunity to put your side of the story. So, Mr. Seleka, you know what Mr. Koko is talking about?
I don't know, Chair.
Okay. Let's start. You continue with questioning
Yes.
as you had planned.
Yes.
When we are done with that, to the extent that during that period, Mr. Koko might not have dealt with some of the issues that he feels need to be dealt with, I will take a break and you and Mr. Berry and Mr. Koko can talk to identify what those issues are, and then we can resume after that.
Yes.
And deal with them.
Yes.
Okay, all right. Just administer the oath of affirmation again.
Please state your full names for the record.
Matshela Moses Koko.
Do you have any objection to taking the prescribed oath?
No?
Do you consider the oath binding on your conscience?
Yes?
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you, Your Majesty.
Yeah.
Yes, Mr. Selena.
Thank you, Chairperson. I would start, Chairperson, by taking reference to Eskom Bundle 14, bracket D. Bracket D, it contains an affidavit and evidence placed or provided to the Commission by Cliff Decker Hofmeyer, the affidavit of Mr. Rishabhan Mutli. The affidavit starts on page 882. Page 882, and deals with a number of aspects. And I would like to pick it up from page 891.
We are dealing with Tegeta now.
That is Tegeta matters, yes, Chair.
Okay. And in particular about the penalties or not yet?
What
we are starting with?
Yes, what we wish to deal with here, firstly, is the issue regarding the hardship clause.
Oh, okay.
Yes, whether OCM invoked the hardship clause, refer the matter to arbitration, and whether the arbitration was pursued.
Yes, isn't that common cause?
That the arbitration was pursued?
Well, I thought it's common cause that OCM invoked the hardship clause.
Correct, Chair.
Further steps were taken to pursue the arbitration route, but it was not pursued to finality.
Yes.
I thought that's common cause.
Yeah,
because if it's common cause, we don't need to spend time on it. We need to focus on those issues where there are disputes.
Yes. What the chairperson was asking last time and engaging with Mr. Koko on was, why didn't OCM pursue the arbitration?
Yeah.
And I thought the chairperson's answer, the answer to the chairperson's question may lie in what is stated partly in this affidavit and in the affidavit of Mr. Clinton Ephron.
Then we can just go straight to that, yeah, no, not to whether they invoked the clause or whatever, because if that's common cause, the only issue is why did they not pursue it to finality?
Correct, yes.
And we can go straight to that.
Chair, part of the audit trail, I talked about the document. I would like you to see the hardship notice.
Yeah.
Because it's going to, I will inevitably refer to it.
Yeah.
But while we are here, can we go to it?
Maybe let's leave that for later. And I may have seen it before, but I'm willing to see it again. But if in response to his questions you have to refer to it, then let's look at it when you answer.
Excellent. Yes. Because the answer lies there, Chair.
Yeah, okay, all right.
The rest is noise and waffling.
Yeah.
Yeah.
Mr. Siligo.
Thank you, Chair. So if I go straight to it, Chair, what you
do
see...
we have any affidavit, or maybe it's what you said, from OCM/Glencore that says here is the reason why we did not pursue arbitration to its finality?
Yes, there is, Chair.
There is.
Yes, there is, Chair. It's in Clinton's Evron affidavit.
Yeah,
And
Mr. Efron.
Yes.
Yeah.
And it is also in the transcripts.
Okay.
I know exactly
You know
what
it.
he said.
Yeah, okay, all right.
Yes, Chair, thank you. There are two time periods, Chair. There's a time period before the cooperation agreement where the hardship clause is invoked in 2013. So this affidavit talks about that. Then comes the cooperation agreement in 2014. Then they suspend the arbitration because they want to talk and reach an amicable solution. Those talks fail when Mr. Molefe comes, where he terminates the cooperation in 2015. Then the reinstatement of the arbitration starts. But then Mr. Clinton Efron says the date of the arbitration was in May 2016. He says that in his affidavit. So May 2016, he gives the date the hearing was scheduled for 16 to 27 May 2016. Before then, April 2016, Tegeta pays the full purchase price for the acquisition of OCM. So the pursuit of the arbitration gets to be overtaken.
Does it deal with why it was taking so long?
Yeah,
Because arbitration is supposed to be fast.
Chair, this is the part that I'm saying. There's an audit trail, and in all respect, you have been misled by your legal team and your investigating team. The audit trail speaks for itself.
Yeah,
I
will look at it.
But let me tell you this: the hardship notice of 3 July 2013 was followed by an arbitration agreement of 12 December 2013. And that
is that the one we looked at the other day?
Yes, and that is 180 days in between. And that 180 days was not a coincidence, because the arbitration clause 30 of the CSA and clause 6 of the first addendum says so. If you don't resolve the dispute on 180 days from the notice date, you then matter must go to arbitration. And the matter was referred to arbitration. And you are right. The arbitration agreement had even appointed the arbitrator, and there was an arbitration agreement, and it had 90 days to conclude. But because optimal, and there is documentation to it that here we have to go through it. Mr. Clinton Efron says he was then approached in his transcript by Mr. Bester to say, rather than concluding the arbitration, let us agree on a cooperation agreement. That is false, Chair. The only proposition is that the arbitration was not taken to its conclusion because the hardship notice has to show special circumstances which excludes the export conditions.
Yeah.
So that arbitration agreement of December 12, 2013 was bound to fail on that basis. The second part of the arbitration, why it was not taken to finality, is that there was a clause for 3.43 notice. You will find it in Clinton Evron affidavit of title C2. It's dated 23 April 2013.
Yeah.
It dealt with coal finances, that the mine as it currently operates can no longer produce those qualities. But that dispute was not included in the arbitration agreement. So the arbitration agreement not only stood to fail, but it was not going to address the coal qualities. That is why they came up with the cooperation agreement.
Let's stop it there, Mr. Koko. As I said, after Mr. Seleka has finished questioning you, to the extent that you will not have dealt with this issue, where that will have...
But Mr. Seleka is already in in August 2016.
No, that's fine.
And
what
that's
I'm
a problem
saying
I have.
we will deal with this. I do want to go through the document trail or whatever that you want to address.
Yeah,
so I will allow you to take me through.
Yeah, but the point is, what happened to the arbitration agreement of December 12, 2013? That's the issue.
Yeah, no, that's fine. Mr. Seleka?
Thank you, Chair. Chairperson, the affidavit of Mr. Clinton Ephron, I'll just read the paragraph. It says, Eskom termination of the settlement process led to the hardship arbitration being recommenced on 23 June 2015, and a hearing was scheduled for the period 16 to 27 May 2016.
I can't understand why.
So you can't understand.
What's the point of going to arbitration if you are going to take almost a year to get to a hearing?
Yeah,
anyway, you can't answer that.
I can answer that question, Chair.
Okay.
Yes.
Mr. Koko, don't address me on the issues now. I will give you a chance later.
Yes.
Let's allow Mr. Seleka to put his questions.
Thank you, Chair.
And when he's done, then we will see how we deal with the issues that you want me to be alive to. Okay.
For that reason, Chair, then we should shift the files, change the files. Let's go to file 18, bracket A.
What bundle?
Eskom bundle 18, bracket A.
Chair, before we do that, Mr. Seleka has made certain submissions and he's made them, I tried to count last night, this is the fourth time he makes it, which are false. And I don't know when to deal with that. But it is false that the cooperation agreement was terminated by Mr. Molefe. It's false, completely false.
And he said Eskom.
No, he keeps on saying.
At least now he was reading from Mr. Ephron's affidavit.
Chair, you see, yeah. Ms. Matonzela has created a story that says Mr. Molefe was brought to Eskom to terminate the cooperation agreement and force Optimum into conditions of hardship. Mr. Seleka continues with the storyline, which is false and not backed up by documents. I want to show you, even in the affidavit of OCM, they don't say so.
Okay, make a note of it. I'll give you a chance to deal with it later on.
Chair, please, because it's blatantly false.
Yeah, make a note of all the issues that you would like to address before you leave the witness stand today.
18A. Thank you, Chairperson.
Yeah, okay, all right. All right, you do have something to write on there if you want to make notes.
I do. Yes, I do.
You do, okay, all right. Bundle 18 page?
Page 423.
Okay.
Chair, I'm going not to respond to some of these things.
Yeah.
But can I say something on this one? We traversed the issue with Mr. Molefe.
Yeah.
We produced his letter to him. Remember, Chair, he was asking for the letter to see what it was worded. And we had to print out his signed letter to give it to him. After the adjournment, he said, okay, It's fine. He accepts this is what he wrote in that letter.
yeah.
So
But Chair,
I'm not sure why
Let him
can I
finish,
finish?
Mr. Koko.
Chair, we're going to go back to that
Can I
letter.
Hang on. Let him finish, Mr. Koko.
So that I'm making false submissions cannot be any further from the truth.
Chair, we're going to go to the letter of May 11.
Can we start, Mr. Koko? Make a note.
Page?
Make a note.
423.
423.
423.
Okay.
So, Chair, so that the chairperson knows what I'm dealing with and can indicate. Chair, this is the emails between Mr. Koko and Mr. Joe Rapela prior to the letter to the DMR.
And Mr.
Joe Rapela.
Okay.
Before Mr. Koko addresses a letter to the DMR, where, which he will explain to you why it was written to the DMR.
Yeah.
Now, Mr. Koko, during your explanation in the evening session of 2 days ago, you told the chairperson two things about this, your communication with Mr. Rapela. One is that in your email to Mr. Rapela, you said these people are threatening us with Ramaphosa. They are the emails on page 423 and 424. Chairperson, by way of
No, I missed your point. You said, what about in my emails? I said what?
Yes, I will tell you. In a chronological order, Chair, they start on page 424.
No, Chair. Mr. Slicker said something I don't understand.
Yes, he says he will clarify to you, but he now wants to give the context before he puts the question to you.
Yes.
Yeah.
So they start from, it's the bottom email on page 424, and they go up in that sequence, Chair, to the page before. Firstly is the email on 5 December 2015 at 12:42 p.m. from Matshela 2010. Matshela 2010 at yahoo.com. And the email simply says, please review and advise. And you will see.
This email was to whom?
This email, Chair, we picked up from the reply that it was to Mr. Joe Rapela.
Okay.
And you will see the reply is the top one on Saturday, December 5, which is the same day, at 8:45 p.m. And the email comes from Matshela Rapela, maliatlala@gmail.com, and he writes, receipt of your email and its contents noted with thanks. Letter is being reviewed and is it too good? And will be sent back with comments covering. Significance of 31 December 2015, and absence of decision makers around that time. Tingly all 3 times without reliable suppliers come 1 January and number of megawatt being risked. A more detailed comment will be sent tomorrow. Now, Chair, what was sent, and Mr. Koko will confirm that, is a draft, I think, to Mr. Rapela. But then it carries on the next page, where Mr. Rapela then gives detailed comments.
The page before or next page?
The page before.
Yeah.
Yeah.
Which is
423.
423.
423, thank you,
Yeah,
Chair.
okay.
But now it's on the 6th of the 12th. The 6th of December 2015 at 14:50 from Mr. Rapela, the email to Mr. Matshela at 2010, and it's a so it's a double reply. It says, my 3G not working, hope you received this. Further to my email of yesterday, I am proposing the following. At OCM, current supply arrangement with the business rescue practitioners, and on 31 December 2015. And we are concerned that they are renegotiating or continuation of current arrangement on the Escoms or the national grid. But then he carries on, their chairperson, I want to ask Mr. Koko this in regard to what he said to the chairperson in the evening session 2 days ago. In a long-winded explanation that Mr. Koko gave, he threw something into it.
Chair, my
And he
response were not long-winded, and I take exception to that. I take exception to that.
I guess in his explanation will do, Mr.
Yeah, no, Chair, I don't tolerate such discussions, such approaches.
And he said, in my emails to Joel Rapella, I said, these people are threatening us with Ramaphosa. And my question to him is, he should show the chairperson, where did he say that in his emails to Mr. Rapella?
Chair, you go again. Mr. Seleka is off tangent. The transcripts will show you exactly what I say. And I'm beginning not to like this, Chair. Mr. Seleka has done it many times, putting words in my mouth, and I've referred you in particular to the transcripts. You can see today I'm not in a good mood. I said to you, I told Mr. Rapella that Optimum keeps on threatening us with Mr. Ramaphosa. He then said he summarized what we discussed. And he then said to me, I must put it in writing. I said to him, no, Chief.
You want to remain factual.
I want to remain factual.
Yes.
That's what I told you.
Yeah, so in other words, from what you said, it's clear that you didn't put it in writing.
Exactly.
But in the you were saying in the discussion,
yes,
that's what you said.
Yes.
Yeah.
So I'm Chair. I'm going to put a stop to this type of line that put words in my mouth that I never said when the transcripts are in black and white. I'm saying this, Chair, because I went to bed last night very aggrieved because I watched the traveling agents here. I watched them reading paragraphs in their affidavit that they disowned. I've constantly told you that your legal team and your investigating people are coaching these weaknesses to the extent that they come here and say, this is not me. I did not write this. And nothing happens. I wrote to you at the beginning that your investigators, Mr. Seleka in particular, are coaching these weaknesses. I'm getting upset, but I don't like it.
As far as Mr. Koko, obviously, if you have something to say about the travel agents, you can deal with that in due course.
I do have.
But my recollection is that as far as you were concerned, as far as what they had to say about you, I didn't think that there was anything in dispute between your version and their version, but you can deal with it later on.
Chair,
Let's continue.
I have a lot to say, but I don't want to be distracted about the falsehood that Mr. Seleka just said now.
Mr. Seleka.
Oh, thank you, Chair. Okay, I have my note, Chair, but we will see the transcript. And then, Mr. Koko, you said, I went to the DMR and I told them, I don't have coal. You have to work with me.
That I said.
So can you tell the chairperson, well, let me say this to you, then you can comment, Ralph. That statement, if you made it at all to the DMR.
I did make it.
Where did you make it?
I met Mr. Rapella. I drove to meet him in Pretoria North. We met, I think the restaurant was Spare, and I did so on 2 occasions. The first occasions was after the meeting I had with the business rescue practitioners on the 28th of October 2015. The meeting that was followed by a letter on the 29th of October 2015. And it's part of the audit trail I want to give you. I met him again in the same restaurant After I received the letter on the 3rd of November 2015, that letter made me not to want to speak again to the business rescue practitioners. It told me 4 things, that letter.
Sorry, which letter?
You will find it in PMM
No, just give me the date.
3 November 2015. I've got it. It's in bundle 15C. It's in bundle 15C. I've got it. That letter, and Chair, this is the audit trail that I will make sure we go through. On the 20th of August 2015, we get a letter. It's in my bundle. It's in 15C that says, we're stopping the belt. You will not get coal. You've got until the 24th on Monday to decide what to do from the business rescue practitioners. I then write a letter to Mr. Mlefe, and we will go into that letter. I then ask a senior counsel's opinion. The interim agreement that the business rescue practitioners proposed was a 30-day agreement.
1 second, Mr. Koko. You know, Mr. Selega,
Yes, Chair.
I'm wondering whether it's not best that we start with this trail that Mr. Koko
Chair,
wants.
we will not go far.
Because no matter how I say, let's finish your questions and then get to it,
Yes.
he,
Chair, we
he
will
goes
not-
back to it.
We will not, we will
goes
not, we will
back
not
to
go
it.
far without an audit trail.
If we do it,
Yes, Chair.
then whatever questions you have later on, then at least he doesn't have to tell me anything about the trail because he would have dealt with it.
Yeah, there's no way.
But he feels strongly about it, and
Chair,
that's
I
why
do.
he. So would that work if we did it that way, or would that disorganize
And I
your
won't be
plans?
long. It will just add 30
No,
minutes
Chair.
in this
30
program.
minutes. Okay. Okay. Let's do it then. Is that fine?
The audit trail.
Yeah. Is that fine? He says it
Chair,
should take 30
no,
minutes.
I know Mr. Koko takes long, Chair. I'm reluctant to agree because I know that Mr. Koko takes long.
Chair, I'm
But
simply going
you
to
see,
the-
we are not starting
Exactly.
with what you want. You see, once he has dealt with it, if he goes back to it, I can tell him you have told me about it.
Exactly, Chair. You can
That's
shut
it.
me down.
So in that way, yeah, I can shut him down. So so I think let's do that now. Because he is the one who wants to deal with it.
Yes.
If it suits you, we can give him the platform. He makes sure that I have the bundle, you have the bundle that is relevant. He goes through without you having to ask him a lot of questions. You can ask him questions after.
No,
But we go
that's-
through and we finish it.
Yes.
What, you said bundle 15?
15C, Chair.
15.
15C.
Yeah, is there an A or B in that
15C.
15C. Yeah, let's go to it and
Said 30 minutes, eh?
just tell us to what page we must start on, Mr. Koko.
Chair, 15C, 1590.
1590. Okay. Okay, just announce again, Mr. Koko, what topic this deals with.
This deals with the acquisition of Optimum by Glencore.
By Tegeta.
By Glencore.
Oh, okay, all right. Yeah, by Glencore, yeah.
Yes. And
Okay.
maybe just to identify the document, please
Yeah.
go to page 1581.
1581.
Yes.
Yes, I've got 1581.
You will see that's a document that was published by,
I just want to make sure the transcript has got this. We are now using Eskom Bundle 15C. Okay, right. Glencore International proposed to be renamed Glencore Extractor PLC. Right. That is at 1581.
and Chair, I need you to go to 1590.
Yes, I've got them there.
And you've got the highlighted part there. I want to read them.
Yeah.
During the second half of 2011...
I'm sorry, you said you wanted to identify the document first. You didn't say what it is.
Oh, it's a document by Glencore
Yeah,
during the merger with Extractor,
yeah.
and it was issued to the investors.
Is that before Glencore acquired Optimum?
Before Glencore acquired Optimum.
Okay, all right. Continue.
It says, during the second half of 2011, Glencore acquired a 31.2% interest in Optimum Coal for $382 million. Following the receipt of applicable regulatory approval, a consortium of Glencore and Cyril Ramaphosa, a prominent South African businessman who is Glencore's local BEE partner, completed the acquisition of the additional interest of Optimum on the 26th March 2012. I want to stop there. So the first point I want to put to you is that Optimum paid Glencore paid $382 million to buy 31.2% stake in Optimum. It then paid, and it means that by October 2011, Glencore was effectively a shareholder, 31.2% shareholder of Optimum. On the 26th of March, they paid another $382 million to acquire additional 30% of.
Well, where do you see? I don't see that 392 in regard to 26 March. Where is it? Well, I see 38 rand per share later in the highlighted portion.
Chair, it's not properly written here, but I have it now, and that I can give you through during break.
Okay,
I have it. I have it. I don't want to waste time, but I have
that's
it.
fine.
But all in all, Glencore paid $760 million to buy Optimum. And the point I am making is that they had two-step at it. October 2011, and then they doubled the investment in March 2016. By October 2011,
2012,
yeah,
March 2012.
yeah, by October 2011, they were in a position to ask for all what they need. They were the shareholder of Optimum. So they can't come here and lie to you that we did not have information to do a due diligence. You were already a 31% shareholder, and you doubled your 31% shareholding. You cannot come to this commission and say you did not do a due diligence because you did not want to increase the shares of Optimum when you were already a shareholder. That's the first part. So they are lying to you, Chair. I don't want to go to the document, but this happens in October 2011. you will remember there was an arbitration that was concluded on the 12th of April 2011 that was signed by Mr. Marukani, that dealt with all the dispute and rights of parties and dealt with the issue of quantity, dealt with the issue of quality, and concluded all the rights. So
is that the settlement agreement?
It's a settlement agreement, addendum 2. Right. So for all intents and purposes, Glencore was aware of all this because they were 31% shareholder. They can't come and say they did not know. Mr. Ramaphosa then became the chairman of Optimum on the 26th of March, replacing Mr. Bobby Godson. So if we are going to implement the settlement agreement of 12 April 2016, it means that Optimum had, on the first day, they had to start paying penalties, or Eskom had to start deducting penalties, because all the disputes were resolved. Chair, from the day one that Optimum took over Optimum on the 26th of April, they never paid penalties other than the abrasiveness index. They never did.
Yeah.
And there was no reason why.
You say from the time that Glencore took over, took Optimum over, and
yes,
after buying the
yes,
majority shares.
Yes, yes, they never deducted penalties. There was no reason why, because there was an arbitration agreement. There was a settlement agreement that says Optimum must do that, and they did not do it. And here I am saying, in my affidavit, it was an ace up their sleeve that they had, and because I'm this commission, the ace up their sleeve at all material times has been Mr. Ramaphosa. But on the 23rd of April, they then issued, is another audit trail. They then
2012 or which year?
On 23rd of April 2013.
Yeah.
They then issued a notice. I'm going to take you to that notice. It's very important. So I'm going to.
It's at page 1799 of this bundle.
1799.
Thank you.
Right, yes, Chair. Now you'll see that this is a notice, it's a letter from Mr. Ryan Duploy of Optimum to PEM, Pile of Eskom, and is dated 23 April 2013. And the title of the letter is that Hendrina Coal Supply Agreement Sizing Specification. And it says, if I could take you to paragraph point 3, it says, OGH has now reached the conclusion that the sizing specifications set out in clause 3.43 of the first addendum are no longer realistically representative of the coal, which OCM can reasonably be expected to achieve from the exploitation of the coal deposits constituting the optimum coal rate. It being the OCM's view, OCM is conducting its operation in proper manner. Right, and then if you go to paragraph 4, it says, we therefore hereby formally notify Eskom that we wish to renegotiate specifications set out in 3.4 of the first addendum as contemplated in clause 3.44 and 3.45. Right. Chair, I took you to the first addendum that now Eskom and Mr. Avlon refers to this attachment, says we stopped deducting penalties because of this document.
I'm sorry, who says that?
It's Gert Opperman in his transcript.
It says Eskom stopped imposing penalties because of this document.
Because of this letter.
Okay, all right.
Chair, is in page 62. you will find that in page 62 of Mr. Gert Opperman's addendum on day 62
Okay.
of the proceedings. Here.
Okay.
I can read to you, but I will
Yes.
not. But
No, that's fine.
Right.
Yeah.
Now, Chair,
So let's just get what this letter says. OCH has now reached the conclusion that the sizing specifications set out in clause 3.4.3 of the first addendum are no longer realistically representative of the coal which OCM can reasonably be expected to achieve from the exploitation of the coal deposits. Basically, OCM is saying we can't meet the contractual requirement relating to the specification. Is that right?
correct,
Yes. And what do they then propose should happen?
to renegotiate the contract.
We therefore hereby formally notify Eskom that we wish to renegotiate the specifications set out. So they want to renegotiate so that there is an amendment to the contract as far as the specification is concerned.
Correct,
Okay?
correct. Now, what they did not mention in that contract, they say 2.43, 2.44, 2.45. They don't mention 3.46, which I want to take you to.
Yeah. But before we go there, the letter would only have penalties, would only affect penalties insofar as there may have been a failure on their part to comply with the contract in terms of specifications of the coal, because they were saying they want to renegotiate that.
Correct.
Yeah, okay.
Now, this is not a reason for Eskom not to deduct the penalties.
Yes.
It's not.
Yeah.
So if Eskom decides to not deduct penalties, it's unlawful. It's an unlawful activity and it's in contravention with clause 55, 50, 51 and 50 and 51 of the PFMA. And maybe one would say it's unlawful because they are not under an obligation to impose penalties. It's a right they have which they can use if they want and not use if they don't want. That is Eskom. Now, Eskom has got the obligations, Chair.
To impose a penalty.
Yes. I can take you to a clause 9.3.
Okay. Please, at some stage, take me there so that I can have a look, so I can understand your statement.
The only remedy in the coal supply agreement for Eskom for non-compliant coal, we discussed it the other day, are two: rejection or penalties.
Yes, but my understanding and what one would expect from a contract such as this is that the issue of penalties would be there for Eskom's benefit. And if, for whatever reason, Eskom thought it was in its interest not to enforce the penalties, even though it is entitled to enforce them if it wants to, it would be within its rights not to enforce. But once Eskom says to Optimum, pay these penalties because of A, B, C, D, then Optimum is obliged to pay. That would be what one would expect.
Excellent, Chair. And your point will apply when I deal with the cooperation agreement.
Yeah.
Eskom has not waived its right
Yeah.
not to deduct penalties.
Yeah. No. I think we may be involved in some technical. You are saying right now. Now, there we are on the same.
No. But
page.
I'm saying Eskom has not.
Yeah.
Eskom has not sat down.
Yeah.
And say, in the interest of Eskom,
Yeah.
we know we have to deduct penalties, but we think it's in the best interest of both parties that we don't do that.
Yeah.
Eskom has not done that.
Okay.
And therefore, the people administering the contract were obliged to deduct the penalties.
Okay. Yeah. You see, when you talk about the people who are administering within Eskom,
Yes.
then
Yes.
the obligation part makes sense.
Yes.
Because they are people within Eskom.
Yes.
If their job is penalties should be imposed, they should impose.
Yes.
Yeah.
Yes, and that's the point. Eskom they are obliged to deduct penalties. Those people have not done that.
Yeah. Okay.
And the letter of CE2 we refer to is not a license for them not to do that. And to the extent that they don't do it, they are breaking Eskom rules and they're breaking the PFMA rules.
Yeah.
So, check, if you go to page 1760.
1760.
Yes.
Yes, start by telling us what that document is.
It's a first addendum to the coal supply agreement. You will recall that the Annexure 3 CE2 referred to 3.44 and 3.45.
Yeah.
And 3.44 deals with what happens in the event that the optimum feels that they can no longer meet their specifications in the coal supply agreement. So they are entitled in terms of this document in this clause to ask for renegotiation of the coal supply agreement. But it does not end there, Chair. If you go to 3.46, 3.46 says in the
To which
event
they did not refer in the letter you said.
to which they did not refer in the letter.
Okay.
In the event that the parties shall fail for whatever reason to reach such agreement, such failure to reach agreement shall constitute a dispute which shall be dealt with in accordance with the provisions of Clause 6.
Now, the matter on which they would be failing to reach agreement is quality
It's quality.
of coal. Yeah.
It's quality of
Okay.
coal.
All right.
So,
and quality of coal or the specification would include quality.
correct.
Okay. All right.
Correct.
Okay.
The letter specifically says sizing specifications.
The sizing specification.
Sorry.
Sizing specification is part of the quality specification. It's a physical property of the
Yes.
quality specification.
Specifications.
Yes.
Yeah.
Right.
Okay.
Now, Clause 6 is arbitration clause.
Yes. You
So-
want us to go there, or we
No,
don't?
we don't need to go there. All I'm saying,
the
Chair,
arbitration clause.
all
yeah.
I'm saying is, I think I can no longer meet the specifications. Let's renegotiate the agreement. We deadlock the dispute arbitration.
Yeah.
Simple as that.
Yeah. Yeah.
And the only arbitration agreement was done was in December 2016. So this dispute should have found its way in the December 2016 arbitration agreement, and it did not.
Is this after the 2011 settlement?
This is
agreement?
after the 2011 settlement.
Oh, okay. So the only arbitration that came after this is 2016,
No, it's December 2013.
2013.
December 2013.
Okay.
12 December 2013.
Yes, right.
Which was, for the reasons I've told you, I told you that the specific circumstances don't include export.
The special circumstances.
Special circumstances don't include export.
Yeah.
Secondly, the sizing specification that is referred here, I've referred you to an affidavit of Mr. Gert Opperman, paragraph 60, that the actual problem here was their operations. The problem was the secondary crusher at the sample stations that they operated wrongly. So they would not win that. In any event, their Mr. Vogel solved it in October 2015. So either way, both disputes they were bound to lose. That is why they then entered into a cooperation agreement on the 23rd of May 2016. And Chair, I don't want to take it to my opinion piece. The purpose of a cooperation agreement did three things. It was to achieve three things: to stay the arbitration of December 2013, to put it on hold. One, two, to suspend the penalties that Eskom were not deducting. So they wanted to regularize that. Four was to enter into a fourth addendum. And it was signed on the 23rd of April. Now, Chair, this is the very important part. It was signed, the person who signed it had no authority to sign it.
Who was that again?
Kiran Maharaj,
Sorry?
Ms. Maharaj.
Yes.
It was an unlawful act, and I'm going to show this to you. I'm going to take you to bundle 15A.
Bundle 15A.
MMK 49.
Tell us what page.
Page 690.
Page 690.
Chair, just for the record, this is the document 321034, Eskom Procurement and Supply Management Procedure. It starts at page 595 of this bundle.
Okay. Page 595, that's where the document starts. And the page that you want me to go to is
690.
690. Yes, I'm there, Mr. Koko.
Chair, for every contract, that is, all contracts in Eskom are approved by a tender committee. We call it PTC, Procurement Tender Committee. They've got a different delegations of authority. And the highest board tender committee is the one of the board, and it adjudicates tenders more than 750,000 rands. There's 750 million rands. And nobody in Eskom is allowed to change the terms and conditions of the contract unless it's got an approval of the original procurement and tender committee that approved it. You are delegated. If you want to make changes on the procurement and on the terms and conditions, you go to the board. The cooperation agreement changed the terms and conditions of the coal supply agreement. Did that. Now, I'm going to read you at the foot of page 690. It must be noted that there is a difference between Eskom internal governance process to authorize a modification and the contractual process to effect a change to the works information or employer's requirements, specifications, terms and conditions of the contract. The internal governance process must first be followed via a formal modification process before changes to the work information or employer's requirements, specifications, including quantities and or design, can be given effect as to the compensation events or variation orders. So you have to follow the internal governance process. And the internal governance process, you find it in page 691.
This is an internal Eskom document which sets out in this paragraph that if you want to change anything in a contract, you must follow official modification processes.
Correct.
Okay, all right.
Correct. Chair, in page 69, bullet point 3, it refers to what we call a commercial...
Sorry, what page?
Page 69, the next page.
691.
691.
Okay.
It refers to the commercial transactions approval form. It says the procurement practitioner arranges for the commercial transactions approval form to be placed on the agenda of the procurement technical committee, or may present the transaction to the relevant dual or triple adjudication for approval, depending on the total approved value and time. requests must be addressed to the delegated approval authority that approved the original contract. Where the revised best estimate of the expenditure plus cumulative contingency value stated in the delegated consent form, that's what the DCF stands for, and or total time exceeds the delegation of the authority, of the original authority, the request must be submitted to the next higher level of authority. So this is good governance. So you needed a commercial transaction form. The commercial transaction form had to be approved by the Procurement Tender Committee that approved the coal supply agreement of Optimum, and that was the Procurement Tender Committee of the board. It's not in place. I've asked for it. I've written to your legal team. Give me the commercial transaction form that was approved by the Board Tender Committee of Eskom that gave authority to the person who signed the cooperation agreement. It was never given. It's not there. So the cooperation agreement is irregular. Chair, I want to take you on the same bundle to MK50. MK50 is in page, and this is the audit trail that you need. Otherwise, you wander in the wilderness. Page 781.
Yes, page 781,
Yeah,
submission document.
Yes.
Or does it start at 780?
It starts in 780, Chair. It is the feedback of the document that served at the Board Tender Committee on the 15th of August 2015.
Okay, and it is a submission document,
And it is a submission document. If we go to the signature page,
and it's executive summary.
yes,
Yes, what page do you want me to go
the
to?
signature page is page 784.
Well, I guess it's important to read what is in paragraph 1 at page 780. Mandate to conclude negotiations with Optimum Coal Mine for coal supply to Andrina Power Station. Okay, that's what it's about.
Yes.
Yeah, okay. Continue.
Chair, I refer you to, if you go to page 781, paragraph 1, 2, 3, 4, 5. It says, based on the risk associated with the above-mentioned hardship notice, the Primary Energy Department sensitized the Eskom Board Tender Committee about the said notice on 12 August 2014 and was mandated to enter into negotiations with the Optimum to resolve prevalent issues in order to get assurance that Eskom could secure coal for Hendrina until and post-2012. So here is Mr. Bester and his team, who says the first time that we notified the Procurement Tender Committee was on the 12th of August 2014, 3 months after the cooperation.
Is he the author of this document?
He is the author of this document.
Okay.
3 months after the cooperation agreement was concluded.
When was the cooperation
23
agreement?
May 2014.
Okay.
Mr. Silika will take you to it. I don't want to waste time.
Yeah, no, that's fine.
So all I'm saying to you is that on paper, it's common cause that the Procurement Tender Committee of Eskom did not authorize the cooperation agreement. And the first time it came to know about it was the 12th of August 2014. Chair, I will take you to the document of the 12th of August 2014 because the only time it went there was because of me. But I want to take you to page 780, read 2.2. It says, Primary Energy Division is mandated to negotiate and conclude the termination of the optimum hardship claim in lieu of writing off the penalties that have been suspended against Optimum since 2012.
PED is what?
Primary Energy
Procurement.
Department.
What department?
Primary Energy Department.
Primary Energy Department.
Yes.
PD is mandated to negotiate and conclude the termination of the optimum hardship claim in lieu of writing off the penalties that have been suspended against optimum since 2012. In other words, penalties had been suspended at that time, and this paragraph says PD must conclude the termination of the hardship claim instead of writing off penalties.
Yes.
Yeah.
And the first thing I'm telling you is that there was no authority suspending the penalties. So the team acted irregularly and unlawfully.
Yeah.
Okay. But secondly, at this point in time, the penalties were, it was in March. If you go to the affidavit of CSH, which I will take you to, the penalties were already 1.3 billion rands that were suspended.
And this is March 2015.
This is March 2015.
Yeah.
The penalties was one
Or April 2015, or thereabout.
yeah, but Chair, the actual number of penalties was 1.9 billion
As at when?
as in April 2019.
2019?
Yes.
Okay.
2015.
2015?
Yes.
Yeah.
Right. Chair, we're going to come to that because this is where you will see.
I'm sorry, before you proceed, Mr. Koko, I was looking at the end of this document because you said Mr. Bester was the author. I don't see his name. Where do you get that from, that he's the author?
Chair, please go to page 796.
There I see his name and signature, but isn't that a separate document?
It's the same set of documents. Chair.
No, you say it's the same set of documents.
Yes, all these documents by the Eskom regulations requires of you to bring all of them together.
But who has signed at the end of the document we were looking at? Because it doesn't give the name, it just says
Chair,
National Executive Acting. And there is a signature. Do you know those signatures? And
Yes,
then it says Group Executive Acting.
Chair, which page are you talking to? Which signature?
At 784, which is
The
end
top
of
one is Mr. Vusim Boweni,
the first one.
the first one,
Yeah.
and the second one is Mr. Edwin Mabilane.
Yes.
And if you look at the next page, on page 785, at the top it says compiler.
At page 785,
Yes.
where does say compiler?
To the chairman,
Yes.
compiler,
Oh, yes, Johan Bester.
Johan Bester.
But that's a different document.
Chair, I agree with you, but if you, the Eskom requirements is that this is a single board document. All of these documents are compiled by Mr. Bester.
Is this document starting at page 785 like an annexure to the one that
Correct,
we're
Chair.
dealing with?
Correct, Chair. Correct, Chair.
So they would be a submission document first, which this document
Correct,
is.
Chair.
And then there would be annexures
Correct,
to
Chair.
it. But in the body of the submission document, would there be something that tells us what documents are annexed so that we know that which documents
Chair.
are?
Yes, Chair.
And do we find that in regard to the documents that follow?
Yes, Chair.
Where do we
Chair,
find
Chair,
it?
what happens, and maybe I don't understand it, is that
Yeah.
the the board submissions,
Yeah, which this one is.
it's a tick box.
Yeah,
So they must, the secretariat will not accept the board submissions unless all these are together.
the documents are together.
Yes.
Yes. No, I understand that part. I'm asking whether in the submission document itself, there would be any reference that tells us what annexures are annexed. You know, in the affidavit
No, Chair, no,
that,
Chair.
that we
No,
do,
no,
you
no,
say
I get your
annexure
point.
so and so.
I get your point, I get your
Yes.
point. No, the
We
answer is
don't
no.
have that.
No, we don't.
Yeah.
We don't.
Okay, all right.
All right.
So in order to know which documents were annexures to this executive submission document, where would we go?
Chair, you don't need to worry because each document stands on its own.
Yes,
Each
but that they went together, that's what I'm talking
Yes.
about. That they went together, how do we know?
The minutes of the board.
The minutes of the board will indicate.
The minutes of the board will indicate it, and Mr. Seleka has it, I can tell you.
Yeah, okay, all right.
No, I
That's
don't
fine.
have it. You will have to
But I
show
got
me.
it from you.
You will have to show you.
Okay,
No, but- Chair,
Mr. Koko, let's continue, we can check that later.
I am very, very, very happy to show you because I have it.
No, that's fine, you can show
have
me,
it, Mr. Seleka.
you can show me later, let's just continue with
Yes.
the trail.
Yes. So
It's
Chair,
now 11:30, Chair.
Chair,
Just to remind you. I was saying, just to remind Chair, it's now 11:30.
Oh, okay, yes. Okay, we've done 30 minutes, actually a little more than that, but you are not finished, I'll give you more time.
thank you, Chair.
Yeah.
Chair, go to page
But
80.
10 minutes should be fine?
I will stop it.
Yeah, okay, all right, let's
Go
continue.
to 783.
783,
Yes. No. Yeah, 783.
yeah,
Chair, paragraph 3.1.3.
3.1.3 here.
Yes.
Optimum hardship and penalty cost.
Yes. Optimum have not met quality parameters in terms of the existing coal supply agreement and hence have outstanding penalties due to Eskom to the amount of 16 million. And at the end of January 2015. Chair, this is a
Why
point.
are they saying 16 million in July 2015?
But Chairman, this is, now you will understand why I was intolerant to this team. Because the penalties are in the region of 2 billion rands. They are lying to the board. They are telling the board the penalties, first they're saying the penalties have been suspended from 2015. And there's no authority.
But you say they suspended them without authority.
They suspended them without authority.
Okay,
And then they tell the board, actually, the penalties that we suspended is not 2.5, 2.1 billion. It's 16 million rands. These are the people we're dealing with, that your investigators are not picking up these things, but they want to judge my behavior. Chair, because I've got 10 minutes, I want to take you back to
yes,
the affidavit of the first, I think it was 14A that we started with Mr. Seleka of CDH, the famous CDH. Chair,
just hang on 1 second. With regard to the conduct of the Eskom personnel
Yes.
who were supposed to enforce penalties
Yes,
that you complained about,
yes.
what is the point again that you seek to make with regard to their conduct in suspending penalties, number one, and two, saying the penalties are 16 million when, according to you, they've gone beyond a billion?
Chair, I've opened a criminal case.
Yeah,
It's a criminal matter. And I'm saying to you, I'm saying to the police, these people were working with Glencore. It can't happen one way.
okay.
This is a criminal matter. I've opened a criminal case. I've gone to the public protector.
Yeah, okay.
But I am,
So that's the reason why you were mentioning it.
yes,
Yeah.
yes.
Okay.
But all these things, Chair, informs my decisions at the end.
Yeah.
When we deal with these other issues.
Okay.
But because of the time, please take me to
Okay.
the CDH affidavit is in 15A.
Eskom,
The one we started with.
Eskom bundle 15D.
I've said 10 minutes, Mr. Koko,
Yeah.
but I do want you, I don't want you to complain that you haven't
Chair,
dealt with issues.
I will
If I must add a little bit in order to make sure you have dealt with, I will add. I just want you to deal with the issues.
Chair, I just wanted to tell you I'm respectful. I don't want to waste your time, but it's very
Yeah,
important that I make the issues that I want to make.
Okay, no,
Chair,
that's
may
fine.
I respect your time.
No, that's
Yes,
fine.
Chair, may I speak? But
Yeah.
one can see the witness is already under time pressure, and he's making mistakes as regards dates and references and so on and so forth, to which the evidence leader is contributing. The witness must have his say, and he should stop feeling pressurized by time. He must do this properly, because he now feels, because of the conduct of the evidence leader, that, he has to rush it, and he shouldn't rush it.
No, Mr. Perry. I think Mr. Koko and I understand each other. I want him to feel that he has dealt with issues. I think in return, he is saying, well, I'm quite happy to do that, but I don't want to spend more time than is necessary. So the bottom line for me, Mr. Koko, is that you must be able to deal with the issues you want to raise properly.
Thank you, Chair. And I will do that.
Yeah.
Yes.
Yes.
So Mr. Koko, just before you move on, I want clarity on the criminal case that you opened. Would that be against Mr. Vusi Mboweni and Edwin Mabelani, who signed the document?
I have listed 8 names, Chair, and I've got it. It's in my car, and I'm happy to give it to Mr. Seleka if he's looking for it.
No, that's fine. But let's take the tea break now. That will give you time to just look at the issues you still want to cover.
Can we finish the CDH matter?
CDH matter.
Yes.
We are at 25 to. We will continue with it after tea. I just want, but it gives you time to also look at these are the issues I want to cover, and then you can cover them. Okay, let's take the tea adjournment. We'll resume at 10 to 12. We adjourn. Thank you. Okay, Koko, Mr. Koko, let's continue. Okay, we continue, just continue.
Thank you, sir. I appreciate for the break. It was worth it. It made
Yeah.
me cool down and think
Yeah,
properly.
okay, all right.
Yes, Chair, while on that, just to recap quickly on the question that you raised earlier, why am I raising the issues I've raised previously? And the issues, the answer that I missed, quite frankly, is that since Mr. Ramaphosa and Glencore took over Optimum on the 26th of March 2012, a host of illegal, irregular activity unfollowed, that includes non-payment of penalties up to the tune of 2 billion rands that Eskom was entitled to. And we've dealt with how the CDH lawyers ill-advised Eskom on the clause 9.6 when the spreadsheet would work. Actually Eskom was entitled to and I'm talking about the project team here, because they were authorized to deduct penalties, and they did not deduct penalties, and Eskom as a whole did not take a decision not to deduct to deduct penalties. And the action by OCM not to go on arbitration, but instead put the business into business rescue was act of impunity.
Business rescue.
Business was act of impunity, and I will also go to it, and I'll refer to it now, because the first addendum of the coal supply agreement makes provision for Eskom to take over the mine. And one of the letters I wrote to Brian was invoke that clause to take over this mine. And
The Eskom may take over the mine under what circumstances? Generally speaking.
For example, under condition of hardship, Eskom can step over and say, if we're going to take this mine, the coal supply agreement makes provisions to that. We've taken legal advice to that, Chair. I will refer you to that legal advice. And the legal advice from the council says now that the mine is under business rescue, Eskom can no longer exercise that provision in the coal supply agreement.
Okay.
And my proposition to you is that Glencore chose to rely on business rescue rather than arbitration to make sure that Eskom does not step in and exercise the clause in the contract that says it is entitled to take over the contract. All of that was an act in impunity, and the ace up their sleeve was nothing else but their political connectivity. Chair, can we go to paragraph 1820 to bundle 15C, page 1825.
Correct,
Chair. Chair, the board of Eskom that I worked under was very considerate, very considerate to the plight of Optimum. They did not take the view that says we've got a coal supply agreement, we've got a hardship clause that excludes hardship. You are in hardship, it's none of your business. It's none of our business, go away. The board of Eskom did not take that line. The board of Eskom was very considerate. The board of Eskom was alive to the fact that if Optimum goes under, we're going to catch the flu. And the document you have...
But that attitude which you say the board did not take, I got the impression that that's the attitude that Mr. Mlefe took.
Chair,
is that a mistake?
It's a mistake, Chair. It's a mistake, and this is the mistake I'm trying to correct. It's a mistake that was first peddled by Mr. Madonsela, and everybody's peddling it here. The documents before you, the documentary evidence before you, shows you that the Eskom board bent extremely backwards to accommodate.
No. I'm not talking about the board, and I'm not necessarily looking at what Ms. Madonsela said or the documents. I'm just recalling my impression of Mr. Brian Mlefe's evidence and his attitude in regard to Optimum, because he said, I think he said what you have said insofar as Optimum's or Glencore's problem being one that is connected with the outside market. One. Two, I think he made it clear that his position, at least that was my impression of his evidence, his position was, we have an agreement with you. You now want us to increase the price. There is no justification for us to do that, and we'll stick to the agreement. That was my impression of his evidence.
I got to that position myself.
Yes.
After Glencore kicked us on the face, when we indulged them. And the document before you now shows you how I, Mr. Matshela Koko, bent backward to accommodate them. And after they kicked me in the face, I showed them a finger.
Okay. We are at page 1825.
The document is in page 1825 is the submission to the Board Tender Committee of 12 August 2014. You may recall that I took you through a bundle 15 where Mr. Bester said the board was informed of the hardship clause on the 12th of August 24. This is the time that the board was informed. Chair, if you go to the...
And I see that you were a signatory to this document.
Correct. Correct.
Okay.
And when Mr. Bester brought to me for the first time around June the hardship position of Glencore, he did not tell me that they've already signed a cooperation agreement. He just told me about the hardship. I said, such a condition, we should not be sleeping. We should be rushing to the board, because the consequences of this to Eskom is bad. So we then put this document, and you will see throughout this document, there is no reference to the cooperation agreement, because I even did not know. So about the cooperation agreement. At that point, my point was, what Mr. Bester is telling me, if I become hard to it, if I say, hey, we've got a contract, they must comply. Is there a way of
that would hurt Eskom?
That will hurt us. That was my position.
So you decided to go to the board.
And then I decided to go to the board to convince the board to say, well, let's look for a middle ground. We know we are right. We know we can enforce our right. But I don't think it will help us. More so that Optimum at that point had already given Mr. Bester a proposal on how to break the deadlock. And Chair, if you go to page 826, I'm going to read it. It says OCM.
Well, just it makes it easier if one can say what the purpose of the document is. Paragraph 1, title of the submission: request for a mandate to negotiate but not conclude coal supply agreements for up to 24 years to ensure the security of coal supply for Hendrina Power Station. Okay? Continue.
So if you go to page 1826, Chair. OCM is currently claiming hardship, citing that Optimum Colliery has not been recovering its cost on the Eskom product over the past 3 years. Based on the current modus operandi, OCM have proposed a price increase from the current 154 rands per ton. After quality price adjustment, this drops to 130 rands per 36 per ton. Year to date, May 2014, to 285 rands per ton for the remaining part of the period, and 375 rands per ton plus profit margin post 2018 to 2023. I'll stop there.
Yes.
So Optimum says to Mr. Bester, we are in hardship. To get out of hardship, we need a price increase from 154 rands per ton to 285 rands per ton. If you go to the bottom of the same page, I'm going to read the last sentence to go to the next page. It says, as the current coal qualities are not meeting Hendrina specifications.
I'm sorry, you said we go to the bottom of the page?
The last sentence. As the current coal qualities are not meeting the Hendrina specification, the primary energy department aims to negotiate but not conclude a real base of 296 rands per ton, which equates to 14 rands 28 cents per gigajoule based on the current higher CV of 20.75 megajoules per kilograms as received. AR means as received. The aspirational base is 190 rands per ton, which equates to 9 rand 20 cents per gigajoule based on the CVs of 20 rands 75 rands per megajoule as received, which is also higher than the current CV of 28.38. So here we were asking the board, we're saying to the board, it's not whether we are right or wrong. We know we are right. We know the contract protects us. But we have a proposal from Optimum to increase the price from 154 rands per ton to 285 rands. However, we also realize that there's quality issues. So let's actually give them 296 rands per ton rather than 285 rands per ton. So that was our real base, and the aspirational base was 190 rands per ton. The board approved this, and there's minutes to that.
Yes.
So the board said...
And this is July 2015?
July 2014, August 2014.
August 2014,
Yes.
right.
So the board says to us, okay, the current price that is allegedly causing hardship for Optimum is 154 rands per ton. We're giving you the authority to go and negotiate between 196 rands per ton to 296 per ton.
Yes.
Chair, it was quite an exciting moment because we know as a team that actually we only have to meet 285 rands per ton.
Yes, okay.
Then we've got a deal.
Yeah.
So we were given the deal,
Yes.
and the deal that we were given, Chair, can I take you back to 1820, page 1825?
I'm sorry, before you go there, first show me where the board approved this request, if you are able to.
Mr. Barry,
Or if it's not here, you can
it's
do
in
it
the
later.
minutes. The minutes are here.
There are minutes that come after
The minutes are in bundle 18.
18.
Yes,
Okay. Mr. Berry can look for them, and then later you can
they are.
tell me. It's just that it's important because I think that it deals with an important issue, namely what you are saying is at least your division and yourself, you were not...
Page 1...
Mr. Koko, hang on.
183.
Hang on. You are saying that this reflects that, at least from your side, you were prepared that the price be increased, even if not to the amount that OCM wanted, but to try and meet them halfway. You were prepared to push that line. That's what I understand you to be saying.
Definitely, Chair.
Yes, okay. Where are the minutes? I see you are excited that you found them.
Page 18.
It seems to be actually more than what OCM had.
The point of it
It's more than we
not
were,
halfway, it's more.
we were giving them more.
No. When I was saying halfway, I didn't mean exactly.
Yes.
I was just saying less than what they wanted, but it go up nevertheless. Less than what OCM wanted.
Chair. The board said give them more.
No. I'm saying we are not in disagreement.
Okay.
I'm saying what you are pointing to seems to suggest that at least your attitude or your units or divisions attitude was that we should not insist on the current price
Yes,
because they are complaining.
yes,
We should increase it,
yes,
even if we don't go up to what they want.
yes.
That's what I'm saying.
Exactly, Chair.
Okay, all right. Where are the minutes?
I thought it was different, Mr. I thought they had proposed 285,
Yes,
but that you were prepared to give them 296.
yes, we are. So the
So,
Oh, okay,
Chair,
okay, that's
yes.
different,
yes,
yeah.
yes, yes.
Oh, you were prepared to give them even more than what they wanted.
Exactly, Chair.
Oh, that's interesting, yeah.
That's why I wanted to correct.
Oh, okay, all right. No, I thought at some stage, maybe it's a different time. I thought at some stage they went to 500 or something.
No, I'm coming to that, Chair,
coming
and
to that,
this is what I call kicking in the face.
Yeah, okay, all right. Let's go to the minutes then. Right.
So, page 1830.
That's where I am.
Those are the minutes.
And it's 1830 of Eskom bundle 15C. Yeah.
Yes.
Okay.
And Chair, the minutes are
This is the board tender committee meeting. This is a board tender committee meeting.
correct, Chair.
Yeah, okay.
Chair,
It's the meeting of 12 August 2014. Yeah.
Chair, the minutes are in page 1841.
1841. Is that where we'll find the resolution?
That's where the
Where the issue was dealt with?
Chair, I apologize. 1843.
1843.
Yes.
Yes, I've got it.
Chair, paragraph 7.5.
Yes.
Request for mandate to negotiate and conclude coal supply agreements for up to 24 years to ensure the security of supply to Hendrina Power Station.
Yes.
And it was facilitated by Mr. Bester.
Is that the discussion?
Yes.
It was facilitated?
Yes.
Yeah, okay.
Yes.
The item was tabled for approval, details of which were included in the meeting pack. All right, continue.
Right. Chair, I am going to read the last sentence
Yeah,
of the first paragraph. I read it, Chair, because that's me saying, talking in the board.
yeah,
That statement is my statement in October 2014.
yes.
And it tells you my state
You
of
say October now? I thought you said
August 2014.
Yeah,
And that tells you my attitude at the time.
yeah.
Yes. It was submitted that historically Eskom was taken for a ride. An adjustment was being done at this point.
Oh, okay, now I see where you're reading. It was submitted that historical Eskom was taken for a ride and the adjustment was being done at this point.
Yes.
That's what you say.
That's what I said. That tells you my attitude.
Yes,
It tells you that my attitude was not an overnight attitude,
yes,
but I was accommodating them because at this point I was saying, but I have a coal agreement. You made millions in the Oxford market. I did not benefit in your upside. Now I must take the downside of your decisions. I will, but I'm unhappy, but I'm drawing the line.
okay.
The board resolved that the primary energy division is mandated to negotiate with Optimum to ensure security of supply for the Hendrina Power Station. Chair, the approval is granted for the primary energy to issue an open tender to secure coal supply post-2018, post the end of the coal supply agreement. And the most important one is the divisional executive, PED, is authorized herewith the power to delegate further to take all necessary steps to give effect to the above, including the signing of any agreements, consents, or other documentation necessary for related herewith. Now, Chair, what the board is saying here, it says, if you manage to negotiate the price below 296, don't even come back.
Yeah, go ahead and sign.
Sign.
Yeah,
Conclude the agreement.
yeah, yes. Well, the last, number one, under resolve that, at page 1843 says, primary energy division is mandated to negotiate with optimum coal mine to ensure security of supply for the life of Hendrina Power Station. That's one. Two, approval is granted for PD to issue an open market inquiry to secure coal supply to Hendrina for the period post 2018, taking into consideration the following. Now, two, what is two about? Is it about getting other stakeholders who may assist to ensure that there is coal security?
No, Chair. 2 is about meeting the requirements of the National Treasury.
Is that in relation to the issue of the price?
No, 2 says the contract ends in 2018.
Yeah, yes.
So when the contract ends in 2018, there's no obligation on Eskom to extend the contract.
Of course, yeah.
So we have to follow the process in the section 217 in the contract.
Yeah, okay. No,
they
that's
must
fine.
tender and tender a competitive bid for Eskom to engage them. And we, quite frankly, expected that they will tender and win the bid, because the next door they've got a conveyor, another person will have to be found.
Yes.
But we have to go through that process.
Okay, okay. And then 3, you are authorized, PD is authorized, you were authorized as Mr. Matshela Koko because you were the divisional executive. Is that right? You are the divisional executive.
No. Mr. Belsa was acting.
Oh, okay. So he's the person who was authorized.
Yes.
Okay. With the power to delegate further, to take all the necessary steps to give effect to the above. Give effect to the above includes 1 at page 1843, namely to negotiate with optimum coal to ensure security supply for the life of Hendrina Power Station, including the signing of any agreements, consents, or other things. So here the board tender committee gave PED complete authority to fix this issue about the the price.
Exactly.
Yeah, and the mandate that you were given as PED was enough to solve this problem because it went even above what OCM was asking for.
Most certainly.
Yes.
Most
okay.
certainly.
All right.
Chair, now I'm going to take you to Eskom 50, bundle 15A.
Yeah.
Page 782. We've been to that bundle.
Yeah, this is important. Yeah.
Chair, all I'm saying to you is once you go through the audit trail, there will be more important things.
Yeah. What bundle must we go to now?
Bundle 15A, page 782.
You see the importance of this part, and this is by this time, Mr. Brian Molefe was there.
No, he was not there.
Is this not 2015?
No, this is 2014, August.
Oh, okay. No, that's fine. I thought it was August 2015.
Yeah, but we'll come to the role of Mr. Molefe, because I think he's the poor old man is just been done hard.
He's not an old man.
He's going to be angry with me. He's going to be angry with me.
Bundle what?
Bundle 15A, 782.
I think I've got B here. Do we not have 15A?
Bundle, I'm looking for MK 50.
500. She says 15A stops at 500. I think she understands that you have given a page number that goes beyond that.
So I'm looking for, it says bundle 15.
Yes, it is correct.
Page number?
The right number. 15782.
782.
Yeah, she says.
Bundle 15782.
Mr. Salega, do we have such a bundle?
Let me check 15D.
The document starts at page 780.
My registrar thinks it will be in B, but it shouldn't be in B if you have it in A.
Chair, let's go with her.
But yours, all of us should have the same thing.
Yes.
What page?
782 is in 15B.
Okay.
Okay, I think the transcript then will have to go with my pagination. 782 is a submission document. Is it 782? Is that the page? No, that starts at page 780. We have looked at that submission.
Okay, so let's go to 780, Chair.
Yes,
Let's go to 780.
I'm there.
780 is the result of the negotiations with the team of Mr. Bester. They are now coming back to the board, and they are saying to the board tender committee, on the 12th of August 2014, you've given us a mandate to go and renegotiate the hardship notice of Optimum. We've done that, and we did not succeed.
How could they not succeed?
That's my point, Chair. You see, you're gonna get to that point now. Now,
Because they were given such a wide
you
mandate.
see, once we get through the documents, you're gonna show that attitude. So let's leave the resolution 2.1. Resolution 2.1 says, Primary Energy Division is mandated to conclude negotiations with Optimum Mine to ensure security of supply for Indrina Power Station at 442 rands per ton for CV 23.5 dry basis from 1 April 2015 to 31 December 2018 to include this new coal supply agreement. The following available right to be exercised by 31 December 2015.
So they are asking the board tender committee for a higher mandate,
Exactly.
maybe close to double the mandate.
Correct, Chair.
Oh, no, not really.
No, I will
Less
take
than
it.
that,
I will
yeah.
take you to the cost implications.
Yes. Okay, but where do we find them saying what the problem was with reaching agreement with OCM on the mandate that they had been given?
Chair, the best you can get, and I happen to know what the issues are, but the best you can get is to go to page 782.
Yeah.
Page 782 says, no, I need this. There's a page where they, yes, please go to 787, page 787, Chair.
Yes.
Chair, we've dealt with these documents and the bundles and the attachments. So this is an attachment we've had this discussion before. So page 787, number 2 says approved mandate parameters and negotiation results. So you'll see that 296 on the left-hand side, approved mandate.
I'm looking for it on this page. Oh, yeah, I see it, yes.
That is
The
the
approved mandate, yeah.
that is the number you saw on the 12th of August 2014.
Yes.
And look at the
Results achieved.
Yes,
442.
yes,
How is it possible?
exactly, Chair. Now remember, when we asked for a mandate, we already had a proposal,
Yes, which was
285,
280 something.
285.
And then you were given a mandate of 296.
We gave them a mandate of 296.
Yes.
Yes,
And they said, you reach agreement, you don't have to come back,
yes,
sign. Yeah.
yes.
So what happened? Where's the explanation of what happened?
So Chair, when I was on suspension here, and when I came back, I was met with the hostility and the arrogance of Glencore. Who are you, Mr. Koko? We are told the Eskom has agreed, and you'll always hear Ms. Chulimatsela made this story that says Eskom had agreed until Brian Molife came. So, Chair, can we now go to bundle 15C?
But before you do that, when PED went to the board tender committee
Yes,
and said, we know that contractually we are right,
Yes,
and we can refuse to increase the price.
yes, that was me. Yes.
Yeah, but we think it's not going to help us to adopt that attitude.
Yes.
We are asking the board tender committee to give us a mandate to negotiate and increase. OCM had put a proposal already.
Yes.
All that needed, and that proposal was within the mandate that was given by the tender committee.
Yes.
All that needed to be done is just to accept that proposal.
Chair, now you're talking my language. Now you're
There was
talking...
no need to negotiate because it was less than what the board was
Chair,
prepared to
Chair, now you understand why I think Tulima Tonzela owes us the apology.
Yeah,
Chair,
but
Chair, please go to page
if
786.
you can take me to where the explanation is,
Chair, that's all what you have in that bundle. That's all what you have.
there is no explanation.
No, there's no explanation. All what the best I can tell you is that I'm an engineer, so I try to understand what they try to do. So they probably, at the face of it, they try to buy coal of the higher energy content for Hendrina. But that was still not the mandate of the board. It does not matter what you think.
Yeah, you see, it's a very interesting, it's a very strange thing.
So it's not strange. The fact
no,
speaks for itself.
Look at this way. In the context of, for example, a trade union. A trade union says, we want you to increase our salaries or the salaries of our employees by 10%. And then a division of the employer of the company goes to the board or whatever to say, we want to resolve this issue. The board says, go back, you can negotiate even if it's more than 10%, up to 20%, but don't come back to us, settle it if it's within that mandate. All that the employer delegation or negotiation team has when they come back is to say, we accept your proposal of 10%. And then the whole thing is done. How does it go up like that now?
Chair, my family, my kids, including my cat, have been through a lifestyle audit. I'm challenging you to get the people involved in legal negotiations to do the same.
Continue.
That's the best I can say. Chair, on that same page, please go to page 796. Chair, I meant it when I say my family and my cat went through the lifestyle audit, and I challenge the people that were involved in these negotiations to do the same.
You say 796.
796.
Yes.
I'm going to read you the impact. Furthermore,
Let's talk first about what document that is.
it's the same document we just looked at.
Oh, it's the last page of the same document.
It's the last document.
It's signed by Mr. Johan Bester, General Manager, Fuel Sourcing, Primary Energy Division, and Mr. Vusi Mboweni, Divisional Executive, Primary Energy Division, as well as Mr. Edwin Mabelane, Group Executive, Acting, Group Technology and Commercial.
Right.
Yes.
So it says in the middle of the page, furthermore, the delivered cost of this alternative source will in all likelihood be higher than the price from Optimum. Okay. As the mine delivers via the, it says the Eskom assessment of the Optimum proposed costs indicate that if agreed to will cost Eskom 5.5 billion at 5.5 billion tons per ton for the remainder of the current coal supply agreement. So the team is saying this proposal to increase the price will cost Eskom 5.5 billion. That's extra.
Which proposal is it? The 449?
The 442.
442 from OCM.
From OCM.
Yeah, which is a new proposal
Yes.
after
Yes.
the mandate was given
Yes,
to
Chair.
PET.
Chair, when I was here, I made you read the minutes of February 26, 2015 deliberately. Because in those minutes, the FD says we are not going to get an equity injection. We are not able to borrow. The best we can do is to go for a MYPD3 reopener, which we did and was declined.
Yeah.
So you can't get money from the tariff, from the regulator. You can't borrow more money. You can't get an equity injection. Where are you going to get the 5.5 billion rands?
And was this known to the team? That was.
They've written it.
I mean, the points that you have just made. Were they alive to them? Were they aware of them?
Of course they were.
They were aware.
Of course they were.
Yes.
They just think that the associates of Mr. Ramaphosa are entitled to bully Eskom, to extract 5.5 billion rands out of Eskom, and nobody says anything about it. And Mr. Tulimanzola misses it. Chair, how is it possible that Ms. Tulimanzola missed this point? That this proposal will cost Eskom 5.5 billion rand that Eskom does not have. And the associates of the President Ramaphosa are entitled to it. How is that possible?
Well, all I'm saying, Mr. Koko, is that the public protector didn't have as much time as this commission has had to look at these issues. And you are raising some of the aspects you are raising have not been raised by any of the Eskom witnesses before. So, and of course, as I understand it, she did not have your input.
Yeah, and she, exactly, why would she not have my input when she passes a judgment that is against me? The rules of fairness expect of her to say, you are implicated, I'm going to make a finding that's adverse to you. What's your comment? Chair,
Okay.
Chair, let's go to...
Chair, may I ask?
Now enter Mr. Molefe, Chair. Now
Hang
enter
on 1
Mr.
second. Yes, Mr.
May I ask Mr. Koko whether the allegations made against specific individuals are contained in any of his affidavits?
He's thinking.
Chair, my main affidavit deals with this. I go to town about how I was treated. I'm not sure which.
I think
I'm asking a different question.
Yeah.
I know the issues,
Yeah.
he has done some addressing of them in his affidavit. I'm asking whether, to the extent that he blames people, has he dealt with that in any of his
blames who?
affidavit? To the extent that you blame certain individuals, have you dealt with that in any of your affidavits?
Well, I think he has complained, I don't know in the affidavit, but previously he has complained that the public protector did not give him an opportunity. Am I right, Mr. Koko?
Correct.
Chair, not the public protector. I'm talking the people at Eskom.
Oh, okay. Well, you see, the last people he mentioned was Mr. Ramaphosa and the public protector. So when you said people,
No.
I thought you were talking about those. Okay, all right.
I would include the president.
Yeah,
in this
the
case.
president, yeah.
Chair, I did not include them, but I've opened a criminal case, I've said before. And not only did I open a criminal case, but I also went to the public protector.
But also, in terms of the people, if I understand Mr. Selega correctly, to the extent that he is referring to the people that you said were supposed to enforce penalties, you haven't mentioned those people by name as far as I understand.
No, I haven't, Chair.
Yeah.
I haven't here, but
Yeah,
in my case with the police and the public
Obviously,
protector, I've
yeah.
done that.
Okay, all right.
Chair, now enter Mr.
Now you want to deal with the situation. So is what you are saying this, that before, in 2014, you had adopted an approach with regard to OCM's proposal or demand or request for an increase that sought to try and resolve that issue. You got the board tender committee to approve your approach and to give your division a wide mandate to increase the price, actually even above, if necessary, what at that time was OCM's proposal.
Correct.
But you say that instead of the team that was negotiating with OCM reaching agreement with OCM on their own proposal, on OCM's proposal at that time, or even if it was more than that proposal, but within the mandate that was given to them, they came back to the board with a proposal from OCM that was 442.
Correct.
Yeah, but now you are going to the stage where Mr. Brian Molefe enters the stage.
Yes.
Okay.
But before then, there was a board meeting of the 15th of April 2015.
Yeah.
I don't want to take you to the documents. I'm going to waste time. But the BTC and the board had no authority to approve this proposal.
The 442.
The 442.
Yes.
Now,
because there was no money.
Because there was no money.
Yeah.
It would have broken the PFMA rules.
Yes.
Now, I've had a lot of merry-go-round.
Yeah.
Why the board didn't do this? Why?
Yeah.
It's simple.
Yes.
The board cannot approve an unfunded expenditure.
Yes, and that was the position.
This was the position.
But the mandate that the board tender committee had given your division was fine.
Yes.
Was funded.
Yes, Chair.
Yeah.
Yes, Chair.
Okay, all right.
But the 442 was unfunded, and the board, BTC and the board could not approve an unfunded decision. I don't know why Mr. Molefe went up and down and did not tell you that. I don't know why Dr. Ngubane did not tell you exactly that. This mandate is unfunded. The board cannot approve an unfunded proposal. It had to send it back to the executive. There's one executive in Eskom. There's one executive. There are no two bulls in one cry. And the executive, the only bull in the crawl at that time was Mr. Molefe. So he had to go and deal with it. But Chair, I've asked you to go to page 1864 of...
what page again?
Chair, before that,
sorry.
in relation to the evidence leader's question of whether these matters have been dealt with in prior affidavits, in fact they have, in quite some detail, in the supplementary affidavit of Mr. Koko, which is in bundle 15.
But he was not talking about details, he was talking about the names of people.
Yes, but the names are
The
there.
names
The
are
only
there.
fact that was not available at that time that the affidavit was deposed to, but the allegation was still, Mr. Koko in these documents said that Ms. Maharaj did not have authority.
Okay.
But if you have regard to bundle 15, it starts at page 1168, and from paragraph 118, and it extends through to paragraph 147. So this is not new before the Commission. It has been before the Commission for a substantial period of time, since December.
Chair, it is correct that Mr. Molefe was new to Eskom.
Yes.
It is correct that Mr. Molefe was not familiar with the operational detail of Eskom. At best, we could say Mr. Molefe is familiar with the PFMA because he's worked for state-owned companies and he was at National Treasury. So at best, we can say he knew that you can't incur expenditure you can't fund. So, but the decision to cancel the cooperation agreement, I don't think he was clued up enough to make the decision. He was not. I mean, I've also listened to the narrative here, but I'm also disappointed with Mr. Molefe for not dealing properly with this, because he could. I blame myself for that, because a lot of what Mr. Molefe did, Chair, was because of me persuading him to do it. And one of the regrets I have is that Mr. Molefe should just tell you that, you know what, talk to Mr. Koko.
Yeah.
Mr. Singh should do the same. Mr. Singh should say, you know what, talk to Mr. Koko.
Yeah.
He is the decision maker. He's been, to the extent that we made these decisions,
Yes.
he persuaded us to do that. And we may have not understood him. And all what I want you to know when you sit alone and make this decision is that on the together transactions, all of them without fail, I am the man,
Yes.
not other people.
Okay.
So, Chair, if I'm taking to page 907,
I take that to mean you take responsibility for
course.
the decision.
Of course, to the extent that I was in the office. Remember, there was a time I was not
You were
in
not
the
there.
office. But I can tell you now, the 1.6 prepayment, the 595 prepayment, the penalties looked no further. Look at me.
Okay.
Chair, bundle 15C.
That is C for you, but we said B for us, isn't it?
No. This time is right, Chair.
Are we back to C?
Yes, please, 15C.
Did you finish whatever point you wanted to make on that last page of that document by Best Mboweni and?
Yes, Chair. The point I wanted to make is that the optimum proposal at 442 was going to cost Eskom 5.5 billion rands,
Yeah.
and we could not fund it from the equity injection, we could not fund it from the debt, and we could not fund it from the regulator.
So it was out of the question.
So it was out of the question.
Okay.
So it's not the reasons of state capture that we did not approve it.
There was no money.
There was just no money.
Yeah.
As simple as that.
Okay.
Chair,
15C, what page?
page 1864.
1864.
64. Chair, there are two important advisory we received from CDH.
Yeah.
One is dated 17 March 2015. I was on suspension by then.
Okay, before that, let's identify what document this is that you are referring me to.
This is a document Mr. Seleka referred to. This is where we started. It's an affidavit of Shaban Moodley of CDH.
Oh, okay, all right. 1864, I am there.
Chair, there are two important.
And what time frame are we at? Okay, this was deposed to in 2020, but the time frame we are looking at is 2015.
Correct.
Okay.
Chair, there are two important legal advices we got from Eskom. One is dated 17 March, we'll look at it now, and the second one is dated 3 March, both in 2015. They are no different to the legal opinions provided by CDH in 2013 and 2014. So CDH has not given a different legal advices all along. It's been consistent all along. So I'm going to take you to
Has the
paragraph.
question been the same?
The question has been the same.
Okay.
The question has been the same. Chair, please go to paragraph 45 on the same page. I'm going to try to read it, Chair.
Yeah.
It's very important that I read it because it deals with the issues Mr. Seleka has been very passionate about.
Yeah, 45.5,
5.
okay.
Prior to the lapsing of the cooperation agreement, CDH provided updated legal advice on the penalty claim and related risks on 17 March 2015 to Ayanda Nteta, Andrea Williams, Pam Pillay, and other Eskom officials. We provide verbatim quotations from a portion thereof for context. We understand that the period for which the penalty specifically for sizing has not been imposed is from March 2012. In order to protect Eskom's accrued rights, we propose that the following be done. Eskom and Optimum immediately and prior to 1 April 2015 agree that the running of prescription in respect of any payment reduction or penalty due to Eskom be stayed until such time a commercial resolution is reached. Alternatively, Eskom institute arbitration and/or action proceedings against Optimum for the sole purpose of staying running of prescriptions in respect of the potential claim it may have. The risk aspects to take note of: an arbitration process only interrupts prescription for a year from the referral of proceedings. The CSA, and this is a very important part here, the CSA provides that all disputes between parties must be resolved by means of arbitration. Should summons be issued, the claim could be jeopardized, as Optimum could raise a point limine that the court does not have jurisdiction to entertain such dispute. Should no agreement be reached relating to the staying of prescription, or should Eskom not institute proceedings to stay prescription, every month which lapses means it forfeits, loses approximately 50 million rands on average. This potentially would have a PFMA implication for Eskom. It should, however, be noted that the enforcement of Eskom accrued rights by action or arbitration is subject to the following: rectification of clause 3.6 of the first addendum, as Eskom and Optimum has opposing interpretation relating to the manner in which payment reduction should be calculated. 6.2, Eskom compliance with all contractual requirements in terms of the CSA and addenda clause 9.6 and of the CSA and 3.43 of the second addendum to inform Optimum on a monthly basis of its failure to comply with the quality specification, including such calculations of the penalty to be deducted from monthly invoice. The prescription of such proportion of the claim not state, the prescription of such portions of the claim not claimed, not stayed in time. Chair, it speaks for itself. This is the advice from the Optimum. It says, we've got issue of prescription. And if Eskom does not institute proceedings, arbitration, Eskom stands a chance to lose 50 million rands a month. Tell me which executive, Chair, will sit and fold his hands.
With that point,
CDH says there are penalties that have not been claimed since 2012 March, and they will prescribe unless Eskom acts,
yeah,
and either institute summons or arbitration. And if it does not do that, Eskom will forfeit 50 million rands a month.
yes. Or the point you are making is, once there was this advice,
Yes,
action had to be taken.
exactly, Chair.
Yes, to institute, to pursue the claim for penalties.
Yes,
That's the point you're
yes,
making.
yes,
And you are saying it was not because of anything else.
Yes.
It was because this is what the advice
yes.
said.
And this is dated 17 March 2015. Brian Modife was still at Transnet.
And he comes.
He comes into this.
Around 20th or 17th April.
He comes in.
It comes when this advice has already been given.
Exactly.
Yeah.
Chair, don't forget the advice of Optimum.
Yes.
They refer to 9.6.
Yes.
It says, but you'll have a difficulty in this claim because of 9.6 clause.
Yeah.
You see how they are misleading, how misleading it is.
But 9.6 says what?
9.6 says, and the bottom of the page, Chair, please
Yeah.
check page 86, they've written it.
Yeah.
It says, Eskom must notify Optimum in writing within 15 days after each day's.
I'm sorry. You are reading from when now? 1866?
The footnote.
Or at the footnote?
Yes.
Eskom must notify Optimum in writing within 15 days after each day's delivery, whether all coals supplied and delivered by Optimum to Eskom complies with the quality specifications. So at this stage, the settlement agreement that you talked to me about 2 days ago, had it happened?
Yes.
Which dispensed,
Yes.
on your understanding,
Yes.
dispensed with this need.
Yes.
Yeah. So you are saying that at this stage, this was wrong.
Yes,
There was no need for this.
Yes.
Because the settlement agreement had superseded this.
yes,
And it said the spreadsheet that would be exchanged every day would be enough. It would constitute compliance.
yes.
Okay, all right.
Chair, I'm taking you to page 911
Page 911 of the same bundle.
of the same bundle.
Okay, and the same bundle is 15C.
Yes,
Eskom bundle 15C. Page 9,
now we are in 3 June.
page 9.
9,
No, it
no,
can't be the
page
same.
1861, I apologize.
1861.
Yes. Paragraph 45.9.
Yes, start by identifying the document before you read.
It's the same affidavit of Mr. Shaban Mutli of CDH.
Yeah, okay.
And now we are in June, Chair.
That's June 2015.
June 2015.
Yeah, Mr. Prime Lefe is at Eskom by this time.
Mr. Brian Murife is at Eskom.
Yeah.
But let me start at paragraph 45.7. It says the
Hang
duration.
Hang on. Where I am, there is no paragraph 45. You said we should go to 1861, isn't it?
No, I apologize, sir. 1868.
1868. Yes, you want to start at 45 point?
7.
Okay.
The duration of the cooperation agreement was extended for a period until sometime June 25,
2015.
2015. In extending the negotiations, OCM conceded to the staying of prescription in March 2015.
Yes.
Despite the extension of the period, the attempt to conclude a new coal supply agreement under the corporations was not proceeded with. And the conclusion, remember, Chair, there was no negotiations. We won 442 rands per ton. We will only conclude this at 442 rands per ton. And Eskom could not do 442 rands per ton. That is the only reason why
No agreement was reached.
the agreement could not be reached. It was not because of reasons of state capture, Mr. Mlifet at Eskom. Not at
There was
all.
no funding for
There was no funding for it. The rest is noise, hearsay, and politics of the ANC.
Right.
And then on 3 June 2015, CDH furnished Eskom with a memorandum of advice and enclosed a draft termination notice to be sent to Optimum. In essence, CDH advised that Eskom should immediately proceed with the institution of the arbitration proceedings in respect of Eskom's accrued rights. In light of prescription recommencing an Eskom PFMA obligation. In addition, CDH advised Eskom to prepare for any potential business rescue proceedings and short supply or stoppage of coal supply by Optimum. Pursuant to the aforesaid, Eskom terminated the settlement process on 22 June 2015. In light of settlement process being terminated, Optimum reinstatement hardship
I
proceedings.
mean, the settlement process there, they talk about the negotiations or what?
They're talking about the negotiations.
Yeah, terminated the negotiation.
Yes. So now let me take you to 45.13. The instructions to proceed with the letter of demand and the arbitration was based on the advice provided in order to preserve Eskom's rights and against the backdrop that it was understood by Eskom that there remain several issues of concern which would need to be addressed and resolved during the lead-up to the arbitration. Chair, this is my point.
Yes.
Mr. Mulife did not know, was not familiar He could not have known this. He had to be advised. And he was advised. And I'm not going to take you to the letter that advised him, because it was a formal letter that went to him.
From CDH?
No, from CDH to Eskom executives, and from Eskom executives to Brian.
Yeah, okay.
It says, based on, maybe we should go there. Maybe we should go
Let's
there.
go there.
Chair, it's MMK 15.
Yeah, that should be in bundle 15A at page 204.
Thank you. 204.
As you please.
That's a summary record of discussion. That's to MMK 15. Yeah, that's at bundle 15A, page 204. But that is
No, Chair.
24 November
It must
2015.
be, Mr. Barry, MMK 12. MMK 12.
That's on page 194. Sir.
I am there, page 194.
Yes. 114.
194.
194.
Yeah. That's a memo from Edwin Mabelane, Acting Group Executive, Commercial and Technology, to Mr. Brian Mlefe, Acting Chief Executive, and Mr. Vusimboweni is copied, Senior General Manager, Primary Energy Division, and it is dated 8 July 2015. The subject is Letter of Demand for Optimum Coal Mine and Optimum Coal Holdings. And in paragraph 1, it says in terms of purpose, it says the aim of this memorandum is to notify the chief executive of the letter of demand which will be sent to Optimum Coal Holdings in respect of the claim for penalties incurred. Yes, continue then, Mr. Koko.
Chair, you've had evidence from Ms. Daniels that Mr. Sabon Mutli and Mr. Tsulanku briefed me and Mr. Mulefe about the prospects of the penalties, and we rejected it.
Yeah.
Now, this letter is signed by Mr. Tsulanku. So he could not have told us that we're going to lose and then authorizes it. So once again, the testimony of Ms. Daniels must just be taken for what it is. We must just.
Nsulangu was the head
Was a corporate-
manager of legal.
He was a corporate counsel. for Eskom.
Yeah, okay, all right.
And you see who compiled it, Mr. Bester?
Mr. Bester compiled it. It was supported by Mr. Neo Chulanku, General Manager Legal, and supported by Vusimboweni, Senior General Manager Primary Energy Division, and approved by Mr. Edwin Mabelane, Acting Group Executive Technology and Group Commercial, and that's on 10 July 2015, as well as by Mr. Brian Mulefe on 15 July 2015.
Chair, what is interesting, and I just, again, I feel pity for Mr. Mulefe. That signature is not his.
Yeah, I see it's PP.
Yes,
Yeah,
he was
but
not.
I assume that he gave authorization.
He did. No, he did.
Yeah.
No, he did. So, Chair, if I can read you the financial implications. Eskom terminated the settlement discussions with Optimum on 22 June 2015, again on the advice of CDH,
Yeah.
which I agree with.
Yeah.
in terms of written undertaking between parties, which by virtue of the termination of the settlement discussion, prescription recommence. In this instance, prescription would recommence on 23 June 2015 in respect of any potential claim Eskom has against Optimum in respect of payment reduction. The recommendation of prescription from 23... The recommencement of prescription from 23 June 2015 thus means Eskom must immediately proceed with steps to preserve Eskom accrued rights. Prescription would only stop running upon a matter being referred to arbitration, hence the compressed time period of such referral contained in the attached letter of demand.
Yes.
And remember, the last letter of demand was drafted by CDA.
Yes, just before that, I'm just going back to the salient facts. The parties, Eskom Holdings and Optimum, OCM and OCH, jointly referred to as, okay, are party to a coal supply agreement with Addenda, which regulates the supply and delivery of coal to Eskom, okay? A number of impasses. This was unsuccessful, and on 22 June 2015, Eskom issued a letter terminating this negotiation process. Okay, no, that's fine. So you have read paragraph 6.
Chair, what then transpired is what is now popular. Then we've got business rescue, then the business company goes into business rescue.
So now the cooperation agreement has been terminated.
Yes.
And CTH has advised that steps should be taken to claim the penalties.
Yes.
Yes. Right, continue.
And then there's a letter of demand.
Yes.
And on the with the 2.15 billion rands.
Yes, yes.
And Chair, I've already told you that these 2.15 billion rands penalties are not bogus. They are documented in the spreadsheet that was relied on by Mr. Snehal to get to the 2.15.
Well, for the sake of completeness, shouldn't you refer to the letter, CTH letter, as page 196, that seems to be the letter of demand?
Yes, Chair, I've put my file away.
No, you don't have to, but I just want to say, I think what I see at page 196 is a letter of demand by CDH to Optimum Coal, and the heading is demand for repayment in respect of coal which failed to comply with the quality specification of the CSA during the period 1 March 2012 to 31 May 2015.
Yes.
Okay, all right.
Chair, on the same letter, I think it's paragraph 6. It says to Optimum, consider this as, if you are unhappy, consider this to go to arbitration.
I think it may be paragraph 5. Further, in the event that Optimum disputes the claim amount, Optimum must provide us with the names of its preferred arbitrators within 5 business days of the noting of the dispute. Should we fail to reach agreement on a particular arbitrator within 7 business days from the date of exchange of the names of the arbitrators, a request shall be made to the President of the Law Society to nominate an arbitrator.
Yeah.
Chair, I note that there's a page missing actually in this letter. The second page is not here.
Oh, yes, I see it's page 1 and page 3.
I believe this letter is available elsewhere, but we will look into it and rectify that particular aspect.
Okay.
So Chair, procedurally, Eskom framework, governance-wise, we cannot be faulted at that stage.
So the point you have been seeking to make for some time by reference to these documents is to say the institution and pursuit of the claims against OCM was based on, among other things, legal advice.
Correct.
But also we reached that point of not agreeing a price increase because OCM insisted on the price of 442.
Correct.
And had they not insisted on that price, we could have accommodated them because we had obtained a mandate from the BTC, which actually went beyond the proposal they had made at that time.
Correct.
Yeah, okay.
Chair, the most unfortunate part then came August 20 letter.
And where do we find that?
The August 20 letter. Nice.
Have you got it?
I have it, Chair. There's
Yeah.
no way I cannot have it because that
Yeah.
is the letter
What
that.
page is it?
Is-
Is that the letter dated 20 August 2015?
yes, sir.
Is that is in bundle 15C at page 1904, 1904.
Chair, this is the letter that broke the relationship. You asked me yesterday when I said, when did the relationship was broken, and he said, when? I said the 20 August 2015.
I'm sorry, that page number, I don't have it on page.
It's 1904 bundle 15.
On 1904. I thought it was 904. Right, this letter, yes. Yes, I'm there, Mr. Koko.
So this is a letter from Werksman's attorneys representing the business rescue practitioners.
Yes. And what is the date of that letter?
20 August 2015.
Yes, okay.
And you'll see for the attention Chief Officer Generation.
Is this a response to the letter?
No.
Not to the demand, okay. Yeah,
Okay, this was pursuant to the meeting I had with them on the 17th of August 2015.
the business rescue practitioners.
Yes.
Right.
And this is a letter terminating, suspending the coal supply agreement.
Yeah,
I'm going to read paragraph 4. You would further be aware from the notices in respect of business rescue proceedings, the hardship claim initiated by Optimum in 2013 and your extensive engagement with OCM pursuant to the settlement agreement conducted in terms of the cooperation agreement between Eskom and OCM dated 23 May 2014. That the principal reasons for the recommencement of OCM's business rescue proceedings is the financial distress that the terms of the CSA have placed and continue to place on OCM. The financial position of OCM was clearly communicated to Eskom on numerous occasions prior to the commencement of OCM's business rescue proceedings in both written correspondence and formal meetings held between representatives of OCM and Eskom. This financial position has been exacerbated by Eskom's recent claim for historical claim and future penalties which, if upheld, will effectively result in OCM supplying coal at Eskom at 1 rand per ton. Okay, I want to take you to paragraph 7. Notwithstanding the aforesaid, Marsden and Van der Steen are amenable to supplying coal to Eskom during the business rescue proceedings on terms which are sustainable for OCM. Accordingly, OCM hereby offers to supply coal to Eskom to the terms set out in the agreement enclosed with this letter, interim agreement, which the interim agreement is based on the principles negotiated between OCM and Eskom negotiating team pursuant to the cooperation agreement. The price included in the interim agreement represents the average cash cost of production of OCM. The costs in the interim agreement are not materially different from the cost provided to Eskom as part of the cooperation agreement process and have only been adjusted to take account of the different time period during which the coal is to be supplied. We record that pursuant to the cooperation agreement, Nedbank and Basis Point Capital were appointed by Eskom to review the OCM costs in detail, and they confirmed that OCM costs were accurate reflection of cost of money. Chair, we will go to the interim agreement. But what the business rescue practitioners were effectively saying to us, we're now suspending the cooperation agreement, and unless you give us the terms that we agreed, we negotiated in addendum 4, go the highway.
The price under the interim agreement that they were
You're going to fall off your chair, Chair. Let's go to PMM 8.
And what page is there?
No.
Or is it a different bundle?
Chair, where is the attachment to this letter, Mr. Barry?
I see PMM 8 is the next page.
No, I'm looking for
I see we have gotten
the interim
past
agreement.
1 o'clock, but I want to finish what you wanted to deal with so that after lunch.
What is the date of the letter you want to refer to, Mr. Koko?
Chair, Mr. Barry, PMM 7 has got an attachment, and that attachment, it is the interim agreement.
Maybe, I'm just trying to think whether we should rather adjourn, then you can look it up during the lunch break.
Mr. Silika, do you have Mr. Pierre Marston's affidavit, because it's in the attachment, is PMM 8. If you...
We have the affidavit without the annexion.
But if we take a break, I will find it, Chair.
Yeah, okay, all right. Would that be the last document you wanted to deal with?
That will be the last document, Chair, because
Okay.
then
That's fine.
it just follows.
Yeah, okay, no, that's
It
fine.
just follows. Then I will
Then you
refer
can
to
face the
I will
questions.
refer to the documents without referring to them,
Yeah.
because after this after the agreement, we then get a letter which kills the cat, that says Optimum under Glencore will only supply coal to Hendrina until the end of December, until the end of January. Now, I heard Mr. Seleka saying to you that, but there was no crisis. There was an interim agreement in place that lasted until October 2016. What Mr. Seleka is not telling, August 2016. July 2016, let's say that. What Mr. Seleka is not telling you, that the interim agreement in 2016 only existed because of the sale agreement of the 10th of December. The condition precedent of the sale agreement of 10 December 2015 was post-commencement funding, which I will take you to when I answer the question. Post-commencement funding by Tegeta. The Tegeta will fund the operations of Optimum from January 2016 to July 2016. That's the only reason why coal was guaranteed and flowed to Hendrina.
Okay. All right, let's take the lunch adjournment. It's nearly 1:10. We'll resume at 1:10.